very good morning to you all. Honorable Mr. Justice C.B. Bajpai, former judge of the Chhattisgarh High Court and former chancellor of this university, and my neighbor in the judges' colony in Bilaspur. He has encapsulated what I wanted to say, which I'll take 40 minutes to say. He has done it in 2 minutes. And if I was to write a judgment, I would have said, I agree, and signed it and sat down. But then your vice chancellor would not be happy. Dr. V.C. Vivekanand, vice chancellor of the APNU. First of all, let me congratulate you for what I've seen last evening and today. I see a lot of improvement in the from where I went there. Please keep up the good work. There's lots more to be done. Also, the same to the registrar and faculty members, the members of the media who are present here to spread the word, and foremost, my dear students. If you will remember, probably I was the only chancellor who went to the boys' mess and had lunch with you. Today, we are celebrating the 74th day of India becoming a republic. It is a very, very important day. For this, it is on this day that the Constitution, which was adopted on 26 November 1949, was formally enforced and we became a republic. I have structured my address in 4-5 portions. I'll deal with the will of the people, with the rule of law, the conflict between them, and in present day circumstances, I will also deal with the basic structure of the Constitution and the collegiate system. Because I really believe to catch the bull by the horns, जो चीजें अखबारों में आ रही हैं उसके बारे में ही बोलना चाहिए. Why should we try to hide and say we will not talk about it? I am extremely grateful to you, Professor Vivekanand, for inviting me to deliver this lecture, the second BR Ambedkar Memorial Lecture. It's a proud privilege to be associated even with the name of Dr. BR Ambedkar, who was the architect of our hospital. However, before addressing on the main topic, I would like to talk about two personalities. One is Justice M. Hidayatullah, after whom this university is named, and the other is obviously Dr. BR Ambedkar, after whom this lecture series has been instituted. Justice Hidayatullah was, without doubt, one of the greatest judges in this country. He was not only a jurist par excellence, but he was also a linguist. He was a poet of sorts. His father was a very great Urdu poet, but he was also not a mean poet. He was, I think he knew 7-8 languages, including Sanskrit, very well. He belonged to Raipur. He had his schooling until the primary level in Raipur. And then he went to Nagpur, went to Trinity College, London, where he obtained a degree in economics and was called to the bar from Lincoln's Inn. He practiced at the High Court of Central Provinces and Berar, which later became the Madhya Pradesh High Court, and was elevated as judge there, and later elevated as Chief Justice of that court. He came to the Supreme Court in 1958, and became Chief Justice of Indian system. And while serving, he has a unique, I think many of you may know it, because recently I saw this also in BR Ambedkar LiveLaw. There was a question that he was the one Chief Justice who served both as acting Vice President and acting President of India. And he actually was later elected to be Vice President of India. The President has a house in Simla near Simla called the Retreat. And all presidents normally come to Simla for a few days in the summers. And they allow the Vice Presidents all to use their residence. So Justice Hidayatullah used to come there very often. I was a fresher at the bar, but I was normally an office bearer or a member of the executive committee And all these years I interacted with him. And whenever we invited him to deliver a lecture at the Bar Association or some other occasion, he would always do so. I've had some wonderful conversations with him. And coming back to the Hidayatullah National Law University brings back memories of my interactions with him. You know, he never made me feel that I was a fresher at the bar. He would talk to you on a one-to-one basis. Today, on the 74th Republic Day, I, as a student of law, pay my humble tributes to Dr. BR Ambedkar. He, also known as Baba Sahib. He was born on April 14, 1891 in Mao in Madhya Pradesh. He was the 14th child of Ramji Sakpal, who was a Subadar in the British Indian Army. Subadar was a fairly high post at that time. Very few Indians reached that post. So Dr. Ambedkar did not belong to a poor family. Let's be honest about it. But he belonged to the Mahar caste. So he was an untouchable, which was worse than being poor. And for a person belonging to the Mahar caste to even aspire to be educated, let alone we reached the level which Dr. Ambedkar did, was something very difficult. But he was made of sterner stuff. And he not only studied, he studied in Bombay, went to Columbia in New York, obtained his doctorate from there, then went to the London School of Economics, obtained another doctorate from the London School of Economics, attended Gray's Inn, and was called to the bar from Gray's Inn. After he came back to India, the Maharaja of Baroda appointed him as advisor of defense, which was almost like a post, a ministerial post, a very high post. He did reach a high post, but his colleagues, who all belonged to the high caste, did not even interact with him on a social level. They humiliated him whenever they could, and therefore he left that high position and turned to practice of law. But law was not his only calling. His main purpose in life became to become the voice of the untouchables. He also was a freedom fighter and published various journals advocating political and social rights of the underprivileged and the downtrodden. These two giants of the legal fraternity, Justice M. Hidayatullah, Dr. BR Ambedkar, came from two totally diverse backgrounds. One from an aristocratic Muslim family, which was full of riches, and one, the son of a Subedar, belonging to an untouchable caste. But this is the beauty of our nation, even in pre-constitution days, that both could achieve these high posts which they did. But obviously, the credit has to go to their own merit. Then in 1947, we attained independence. It was decided to form the Constituent Assembly to draft the Constitution. No civilized country in the world can exist without a written Constitution. But we have one. England has no written Constitution. But they have a lot of, they believe in customs. They believe in history. They believe in precedent. Therefore, they've never, even without a written Constitution, they've done a wonderful job of doing it. So when this Constitution, Dr. B. N. Rao was appointed the advisor to the Constitution, Constituent Assembly, and he presented a draft Constitution, which was based on the 1935 Government of India Act. Now, then you had 200 odd, almost 280 or 280 some members of the Constituent Assembly. 280 something, and 233 were high caste Hindus. That was the. So you had a high number. Now you couldn't discuss it, so a drafting committee was constituted. which consisted of the best legal brains of that time, including Naladi Krishnaswamy Iyer and so on. But the president of the Constituent Assembly, Dr. Hidayatullah Prasad, appointed Dr. BR Ambedkar as the chairman of the drafting committee. And he did a wonderful job as the chairman of the drafting committee. You see, no better compliment can be paid to Dr. Ambedkar than what Dr. Hidayatullah Prasad himself said, and I quote, "Sitting in the chair and watching the proceedings from day to day, I have realized, as nobody else could have, with what zeal and devotion the members of the drafting committee, and especially its chairman, Dr. Ambedkar, in spite of his indifferent health, have worked. We could never make a decision which was or could be ever so right as when we put him on the drafting committee and made him Christian." So this was the acknowledgement by his parents, by Dr. Hidayatullah Prasad. Now, what was Dr. Ambedkar's contribution? There was a lot of thought at that time. Should we have one man, one vote, or one woman, one vote? We got one person, one vote. I'm trying to be gender neutral. One person, one vote in 1950. There are many advanced countries, including some cantons in Switzerland, which got this only in the 2000s or the late 1990s. And women were not entitled to vote in these so-called advanced and civilized nations still as far back as 20, 25 years. So he was a great voter of the universal adult franchise. He was also a great votary of ameliorating the sad situation faced by the scheduled castes, the scheduled tribes. Some things are best said in the words of men, in the way they feel, and I quote Dr. Ambedkar. When he said, when the Constituent Assembly was ratifying the Constitution on 26 January 1949, and I quote, "We are going to enter a life of contradiction. In politics, we will have equality, but in social life, we will have inequality. Because you may give a vote, but you won't marry your son to the untouchable. In politics, one man, one vote, and one vote is equal to one value. But in a social and economic structure, continue to deny the principles of one man, one value. How long shall we continue to live this life of contradiction? How long shall we deny equality in our social and economic? I just ask you to look within yourselves. Have we even today achieved or anywhere near what was Baba Sahib's dream? I don't think so. He was also well aware that giving votes to everybody is not going to be the final solution. I am of the view that the men and women who drafted the Constitution, they were not bogged down like our present-day politicians with vote bank politics. They had no communal thought. They had no caste-based thought. They never thought कि मैं हिमाचल से belong करता हूँ, कि मैं छत्तीसगढ़ से belong करता हूँ, कि मैं चेन्नई से belong करता हूँ. They never thought of the province, the village, the state. They thought only of the country. And if all of us think only of the country, things cannot go wrong. They go wrong because we think not of the country but of other things first. Constitution of India is a very, very long document. It is one of the most finely crafted constitutions in the world. Our Constituent Assembly took ideas from Ireland, from France, from America, and you probably can't find a better constitution. But the heart and soul of the Constitution is encapsulated in the preamble of the Constitution, which I find also embedded on the entrance of the instrument. And it bears repetition each and every day. And I will repeat it before you. We, the people of India, have been solemnly resolved to constitute India into a sovereign democratic republic and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, that's brotherhood, assuring the dignity of the individual and the unity of the nation. The words socialist, secular, and integrity were added by the 42nd Amendment. I'm not dealing with them because let's deal with what the founding fathers or mothers said at the time when the Constitution was drafted. Now, what did we promise ourselves? Justice, liberty, equality, and fraternity. ये चारों चीजें एक अलग-अलग नहीं चल सकती. They have to move together. There can be no justice without equality. There can be no justice without liberty. There can be no justice without fraternity. And if you tag one to the other, they all have to be read together. Now we come to the will of the people. And there can be no doubt, as Dr. Bigway said, that the will of the people is supreme. But what is the will? Recently, others said, a lot has been said of the will of the people, especially with regard to the basic structure of the regime, and come to that later. We are a country which has elections every 5 years, and sometimes much faster because of political category. We have more elections than are called for, and we elect our representative to represent us in the state legislature as well as in parliament. We follow a one vote, one for every person. That is as constituted before. But we have a system which is the first past the post system. That means that the person who gets maximum number of votes polled gets it. I'm not criticizing the system. Please understand, I'm not criticizing the system. In fact, my belief is this is the best system we can. But does this system ensure that the representatives of the people who are elected to govern us according to the Constitution represent the will of the people? Because we are dealing with what is the will of the people. You will see that almost none of the candidates get 50% of the votes. Polled. Somebody gets 30%, somebody gets 40%, but because there are 10 candidates, 5 candidates, 6 candidates, and they get elected. So 70% people have not voted. And look at another factor. In our country, average polling is only about 60%. 50 to 60, 65%. So 2/3 of the people don't even vote. I have got the figures for the last 2 general elections, and the ruling party in the central government got 37% votes in the 2019 elections and 2004 and 31% votes in the 2014 elections. So they had one third of the votes polled. And if you take them to if you extrapolate this number to the total number of the eligible electorate, it will be less than 25%. Please do not say that. I'm not at all saying they are not elected to represent us. They are our representatives. They have been given the constitution mandate to govern. But can they claim that they are the will of the people with less than 25% of the vote? Then another aspect is that we never fight elections. Unfortunately, we never fight elections on policy, whether economic, social, political policies. We fight elections on vote bank basis. We fight elections on communal basis. We fight elections on regional basis. We fight election on caste basis. We promise sops and freebies to the voters. Have you ever read? कभी आपने सुना है कि कोई इलेक्शन के टाइम पे कैंडिडेट बात करता है रूल ऑफ लॉ, will of the people? Does any candidate talk of the collegium system, of the basic structure of the constitution? Now, when these issues are not before the electorate, and the electorate is voting whether every woman should get 2,000 rupees, whether there should be a laptop for every student, and how we will govern, then where is the will of the people to say that we will change the basic structure of the constitution? Now, for me, I am very clear that the elected representatives who are elected to govern do not represent the will of the people. And therefore, my answer is a emphatic no. But assuming for the sake of debate, we are discussing things, assuming for the sake of debate that they represent the will of the people. Then even if it is the will of the people, can it override the rule of law? That will be the second question. I have talked to you about the 4 rights of justice, liberty, equality, and fraternity. And in my view, every law which Parliament passes has to be in sync with what is said in the preamble of the Constitution, because that is the heart and soul of the Constitution. Again, I can do no better than quote Dr. Ambedkar. Normally, I'm known for not quoting many people in lectures or even in my judgments, but here I can do. There are some words which he has quoted so well that I can't do better. He says, these principles, this is I quote Dr. Ambedkar, these principles of liberty, equality, and fraternity are not to be treated as separate items in a trinity. ये ब्रह्मा विष्णु महेश नहीं है. They are together one entity. They form a union of trinity in the sense that to divorce one from the other is to defeat the very purpose of democracy. So if you talk of equality, you have to talk of fraternity, of brotherhood. Liberty cannot be divorced from equality. Equality cannot be divorced from liberty. Nor can liberty and equality be divorced from fraternity. Without equality, liberty would produce the supremacy of the few and the many. Equality without liberty would kill individual initiative. Without fraternity, liberty, equality would not become a natural course of things. It would require a constable to enforce. Police ka danda chahiye hoga if you want to enforce when you fraternity, if you don't talk of equality. You are all students of law. Some of you are teachers of law. But anybody in the legal fraternity always remains a student. The minute you think that you know the law, you cease to be a member of the legal fraternity. Because it's such a wide campus spectrum that none of us can ever say that even we know 1/100th of the law. But one thing is very clear, that we have a system of separation of powers. The separation of powers between the legislature, the executive, and the judiciary. These 3 wings have been created as a system of checks and balances. And this system can work when each wing respects the other, when each wing does not encroach upon the other. No wing is supreme. Neither the Supreme Court of India is supreme, nor Parliament is supreme, nor the Government of India is supreme. What is supreme? what is supreme is this, the Constitution. My old feather-bound Constitution, and I can tell you, now this is not part of my lecture, but I'm telling you, I think Justice Deepak has seen it. On my table, from the day I became a judge, I have the plaque with the preamble to the Constitution on my table. And whenever I've had difficulty deciding any case, I read that preamble again and I see how it fits into the case. And I've always found the answer in the preamble. That's how it works. Now we come to what is the rule of law. You must understand what is the rule of law before you have a discussion. Aristotle, you all know, he was a great Greek philosopher. He wrote, law should govern. So it should law and not men who govern. The basic principle of the rule of law is that the state governs not in accordance with law and not according to the whims and fancies of men. It is very often said that even in ancient India, there was dharma, there was nyaya, and that rule of law is embodied in it. They were great rulers, and some of the concepts of nyaya and dharma are as good as any other in Western civilization. But please remember, the rulers were not themselves bound by nyaya or dharma. I'm not a very great fan of the Manusmriti, to be honest. But even when we talk of very good rulers, they could dispense justice very well, but not when it came to them, because they were always above the law, because they had divine rights. They claimed to be, all our rulers said they are descendants of Bhagwan Ram or Bhagwan Krishna. So how could they be under the law? In more than 1008 years back, as far as the civilized world is concerned, the very genesis of the rule of law came when the Magna Carta was signed in England on June 15, 1250. Now, what led to the Magna Carta? On one side was the church, saying the church is supreme. On one side was the king, who said, I have the divine right to rule and I am supreme. और इन दो पत्थरों के बीच में it was the citizens who were being crushed. So finally peace was brokered and the Magna Carta was signed. There are two articles of the Magna Carta which I want to read out before. And please listen to them carefully. And if you have time and the interest, then go to the library and read them again and think if better words could have been written. I quote Article 39 of the Magna Carta. It reads as follows. No free man shall be seized or imprisoned, or stripped of his rights or possessions, or outlawed or exiled, or deprived of his standing. Please remember, deprived of his standing. I'm talking to you in the Indian context of untouchability and caste. In any other way, nor will we proceed with force against him or send others to do so, except by the lawful judgments of his equals or by the law of the land. It virtually encapsulates what is said in Part 3 of our Constitution and Fundamental. Each and every fundamental right is in one article. But most important is Article 40 of the Magna Carta, which reads, and I quote again, to no one will be sold, to no one deny or delay rights or justice. These beautiful, stirring words written more than 1,000 years back, is the reason why England, without a written constitution, still strives as one of the old democracies in the world. What does it these mean? That's word. These words mean that everybody shall be treated equally. Nobody's rights will be taken away. Nobody's standing will be taken away, except in accordance with law. Now, the other development of the rule of law is when I think the first decision in respect of rule of law was given. The year is 1608. The place is still in England. We follow the Anglo-Saxon law. We have a colonial background. So good, bad, or worse, we have to go back there. The year is 1608, England. King James the First is ruling, and Lord Coke is the Chief Justice of England. The Royal Courts of England that went there. Now, under Justice Coke, many administrative actions were being set aside by issuance of the writs. So, King said, what is this happening? How can you do this? I am the ruler. I have the divine right to rule. How can you set aside my actions? And on 13 November 1608, he said, all the judges have been appointed by me. They are my delegates. So I have the right to withdraw any case from their court and take it up myself and decide it in the manner I want to. So before that, Coke had answered when this thing, Coke had answered, and I quote, that the law is the golden wand and measure to try the causes of the subject, and which protected His Majesty in safety and peace. So he says the law is what will govern the people, and the law is what will protect the king also. That means it is the law which protects the government and the law which also protects the people. King says, nothing doing, I am not subject to the law. To which Justice Coke said, and this is written in writing, it's a judgment, the king himself ought not to be subject to man. So, the king, as king, you are not subject to any man, but you are subject to God and the law, because it is law that makes you. So, where do we judges come from? We are appointed under the Constitution. Where the Prime Minister and the ministers come, they are also appointed under the Constitution. We are all creatures of the Constitution. We are all subservient to the Constitution. The Constitution is not subservient. So the rule of law implies that every citizen is equally subject to law. It stands in stark contrast to the idea that the ruler is above the law. The rule of law, it's a very wide concept. It's a dynamic concept. It keeps changing. But there are certain essential features. I'll just list them out hurriedly. One is the supremacy of it. The law is supreme. A concept of justice where some standards are laid. Restrictions on the exercise of discretionary power. Discretionary power, even Article 142 of the Constitution giving powers to the Supreme Court, must be exercised in a judicious manner. The doctrine of judicial precedent is part of the rule of law. Otherwise, you will keep changing the law. Otherwise, you will keep changing the law. So you have a judicial precedent. And laws should normally be prospective and not retrospective. You can't say today on 26th January 2022, something which is 23, which is something which is not an offense, you make it an offense on 27th January. So laws would normally never be. In tax and all, it's a different, but the laws relating to rights and criminal laws, they have to be. And independent judiciary, I should be talking about this more, is an inherent feature of the rule of law. As Justice Bajpai said, the exercise by Parliament of the legislative powers and restrictions in accordance with the Constitution and the restrictions placed. And very importantly, an underlying moral basis for them. I think some of you must be aware of the judgments on constitutional morality given by Justice Dhananjay Chandra and Justice Nagmi. So there is also, we will introduce this, that they are in accordance with the spirit of the Constitution. So I'm just reading out a portion of my speech because this I don't want to change. In my view, the concept of rule of law implies that the laws must be framed in a manner that they do not impinge upon the human rights of individuals. All human beings should be treated equally. Once the law has been framed, it must apply with equal vigor to each and every person, which will include those who rule. The essence of the rule of law is that every authority is subject to and governed by law. The opposing idea is a state of affairs in which the will of an individual or a group, such as a political party, a majority, acts. Now, majoritarianism is very, very dangerous, as I will show you in a few minutes. When there is a rule of law, there is fairness. And when there is no rule of law, there is arbitrariness. There is anarchy when there is no rule of law. Another very important aspect of the rule of law is judicial review of executive action and legislative function. Are the laws framed in accordance with the Constitution? Are the actions taken in accordance with the laws or the Constitution? And that is why there is the system of separation of powers. The right of fair trial is also part of the rule of law. All judgments should be published so that people know about them. And today, the Chief Justice of India is going to ensure that judgments are released in regional languages also. So it's very easy to say ignorance of law is no excuse. But as I said earlier, even we who belong to the legal fraternity don't know 99% of the laws. How can you expect a poor citizen to know all the laws? So you have to make it easy access to court is another important aspect of the rule of law. To put it very, very simply, I would say rule of law is to do something which is right, something which is honest, something which is fair, something which is truthful. If you follow these, then it is according to the rule of law, otherwise. Now comes the role of the judiciary. It is the duty of the courts to enforce the law. This is the duty enjoined upon by the Constitution. They do so not only by deciding disputes between citizen and citizen, but keeping in view the federal structure of our Constitution. They decide dispute between citizens and the state, between citizens and the union, between states and states, between states and the union. So it is more important that we hold the scales of justice even, and the judges must carry out their job without fear or favor, affection or ill will, to the best of their knowledge, ability, and judgment. This is the oath we all judges take, Justice Bharpayya. But another aside, another secret which I may reveal. During my period as a judge, every time when I went for my morning walk, which was almost every day, unless I was unwell, I would remember I would revisit my oath early in the morning. I would not chant any mantras or anything. I would remember my oath. Because as you sit as a judge, it is this oath which is more important. It is this Constitution of India, which is my Gita. It is this Constitution of India, which is my Bible. It is this Constitution of India, which is my Guru Granth Sahib. It is this Constitution of India, which is my Quran, if I'm sitting and acting as a judge of a constitutional body. We are promised equality, justice, fraternity, and the courts are bound to ensure that these do not remain mere words in the Constitution. But all the citizens actually get access to the courts and are not denied what is due to them under the Constitution. The liberty of any citizen should not be curtailed without following the due process of law. See, the importance which Dr. Ambedkar and his team gave to the fundamental rights and to the right of the court is best reflected in Article 32 of the Constitution of India. Probably we are one of the few, if not the only country in the world, where the right to approach the highest court of the land, that is the Supreme Court of India, for enforcement of fundamental rights is itself a fundamental. So that is the importance we give. As a principle of governance, the rule of law, like democracy, and the separation of powers is an integral part of our body politic. It is the golden thread which runs and binds our constitution together. If we don't have the rule of law, then this constitution will not survive. You know, anytime, anywhere, even if I had a vote here in this hall, if we had a poll here in this hall, and you were asked to choose, I'm sure the choice would always be the same. Freedom, not tyranny. Democracy, not dictatorship. The rule of law, not the rule of men. The bedrock of our democracy is the rule of law. And therefore, it necessitates that we must have an independent and fearless judiciary, which is not cowed down by anybody. There can be rule of law only if we have judges. You know, the oath says, the first word in the oath is without fear or favor. जब हम शपथ लेते हैं, without fear or favor. So the first word is fear. And unfluenced by any extraneous countries. A free country is one where there is freedom of expression and governance by the law. A free country is one where when a session attends, any one of you can get up and say, Justice Gupta, you were totally wrong. I disagree with you on this. And we can have a discussion. And we can discuss in a civilized manner. We can agree to disagree. That is the beauty of it. We don't have to fight and kill each other because we disagree with it. Violence is anathema toward democracy. When there is no sharing of power, no rule of law, no accountability, all that it will result is in abuse, corruption, subjugation, and indignation amongst the people. When the rule of law disappears, if the rule of law disappears, we will be ruled by the idiosyncrasies and whims of a few. Please, my fervent request to you, never let that happen. Now, recently the Honorable Vice President said that he does not believe basic structures. And that brings me, we've talked about will of the people, we've talked about what is the rule of law. So I talk about the basic structure. He's entitled, as I said, he's entitled to his view. But I'm rather surprised, if not shocked, that 49 years or almost 50 years after Keswanandan Bharti's case was decided, and there have been a number of judgments after that, Minerva Mills, IR Koholo, then the NJC case, and many others where it has been established that the basic structure doctrine is very good for the country. A voice is not being raised that this basic structure theory goes against the Constitution. You all have read a little bit of history. In 1933, Adolf Hitler was elected to be Chancellor of Germany. He was elected by popular vote. Please remember that he was elected by popular vote. Germany had a constitution known as the Weimar Constitution. And that constitution had a provision, like ours, that constitution can only be amended by a two-thirds majority. In our constitution, we have another future safeguard, which is that in respect to certain constitutional amendments, the 50% of the states also have to ratify this. Now, what they did was, using their brute authority, they made so many amendments that they took away the rights of the citizen. Hitler used his brute majority to change the entire constitution and take away the rights of the citizens, including the right of freedom of speech, association, residence. You know, we think of residence, Article 9 talks of residents who can live anywhere in the country, and habeas corpus. They also passed a law. The parliament passed a law that hereinafter you don't have to bring anything to parliament. Executive, we delegate our power to the executive to now pass any laws, and the executive doesn't have to follow this two-thirds majority or anything. Why should they follow? They're the executive, they'll do. And we know what happened in India. Millions of Jews belong to a minority community were killed in state-run pogroms. The Holocaust is something which should never be forgotten. As an adult, I've been to two sites where tales have been brought to my eyes. One is the Andaman Cellular Jail, when you visit and see what your freedom fighters have done for you. And the other is when I read anything or visit anywhere concerned with the Holocaust, which took place against the Jews. So when Germany, after the Second World War, when the Federal Republic of Germany, that is West Germany, was drafting its own constitution, they said we'll have some basic clauses which can never be. So from clause 1 to 19.1, even 20.9, sorry, from article 1 to 20.9 of the new constitution, which included the principles of federalism, democracy, rule of law, separation of powers, fundamental rights, they were taken out of the amending powers of the constitution. They said these basic laws are eternal, they will live for eternity, and no will of the people or nobody can. Now, one of the great legal minds from the academic world who talked about this basic structure theory was one Professor Konrad Dietrich from Germany. And in 1965, he was asked to deliver a lecture at the Banaras Hindu University on this issue of the implied limitation on the amending powers to the Constitution. So he spoke about the German experience, and he argued that even under Article 368, though the power to amend is there by two-thirds majority, the Parliament cannot amend something which is very basic to the Constitution. Now his paper was published. Very few people attend lectures by academics. I'm lucky that today the hall is full, but normally I address empty halls half the time. But his paper was published, and a very great constitution lawyer of those times, Dr. M.K. Nambiar, got that paper. His son, Dr. Nambiar's son, is Mr. K.K. Venugopal, who was just the former Attorney General. So, Mr. Nambiar, when he argued Gorakhnath's case in 1967 before the Supreme Court, did present Dr. Conrad Dietrich's paper and argued on the basic structure of the Constitution. In Gorakhnath's case, the theory of the basic structure of the was not accepted, but it was not rejected also. And they said there is force in this argument, but we will see it in a better case on a better patent. थोड़ी सी reluctance होती है to look at a foreigner for advice. But in 1973, when Keswanandan Bharati's case was being argued by the most brilliant lawyer this country has ever seen, Mr. Nani Paduka, not only a brilliant lawyer, but one of the greatest humanists this country. the most gentle soul, unassuming, humble. When Mr. Palkiwala went to address, he, according to Mr. Fani Nariman, he did not carry any books with him. He did not carry any case law with him. He only carried one paper, which was the paper of Conrad. And with that paper on the limitation on the amending powers to the Constitution, he succeeded in case law. And that is where the theory of basic structure became a doctrine and a part of our judicial system, our jurisprudence. But there's an interesting, I was talking to Mr. Fani Nariman one day, and he said, no, it is not Conrad Dietrich who is the author of this. He said, actually, Justice Cornelius, Chief Justice of Pakistan, in 1963, used the, he didn't use the word basic structure, but also said that the Parliament had no power to remove a fundamental feature of the Constitution. It's a similar thing. This was said in Fazlul Qadir Chaudhary versus Muhammad Abdul Haq in 1960 by the Pakistan Supreme Court in 1960. And this view of the Pakistan Supreme Court was found support in the Indian Supreme Court in Sajjan Singh's case, which you are all well aware of, where Justice Madhorpa referred to the Cornelius, Justice Cornelius' judgment and said that this is a basic feature of the Constitution. So this is a mixture of ideas. Maybe for all we know, Justice Cornelius may have got it from Conrad Dietrich also. We're not sure. But what will happen if we do not follow the basic structure? If we say the will of the people is supreme and you can change everything and you do not even have to bother about the basic structure, then Parliament can say, we remove sovereign from under preamble. Parliament can say, we divide this country into four. Parliament can say, we do not want this country to be a democracy. Let it be a monarchy, or worse, a dictatorship. If the basic structure theory is not there, then with 2/3 majority, Parliament can say, we take away all the fundamental rights, or abridge them in a manner which makes them unenforceable. Parliament could delete Article 32, or worse, could delete Chapter 3 dealing with the fundamental rights. Parliament, by a majority of 2/3, could remove Article 13, which says no law can be against the Constitution, or can remove Article 14, which promises equality to all. Can this ever be the will of the people? The answer has to be in check. Therefore, Parliament, even if it represents the people, cannot change what is the basic structure of the Constitution. It is now an integral part of our jurisprudence. And no doubt, Constitution must change over time. Constitution must also be dynamic. We have to keep with the changes. But there are certain core values, certain basic values, what the West German constitutions, or now it's the German constitution says, what are the eternal values? They never. Now coming last to the collegium. If anybody has seen any of my articles or something in the recent days, I myself am not a very great fan of the collegial system as it stands today. I myself feel that it requires a lot of improvement. It has to become more objective. It has to become more transparent. However, with all these shortcomings, I do not see a better alternative. It has been said that some of the best judges, including Justice Hidayatullah, were appointed when the government had the power to appoint and there was no political system. But around 1950 to 1973, if you look at the history, you will see that all names sent by the Chief Justice of a High Court were accepted by the government. There was never a difference of opinion. Because I'm not saying even the Chief Justice never thought of caste or this or that. They also never thought of giving the juniors a representation on the bench. It was made on merit. Obviously, merit also has its different connotations. And the government never disagreed. It was in 1973 when this famous case one of the Bharti case was decided that the top three, that is Justice Hegde, Justice Sharad, and Justice Shah, were superseded, and Justice A.N. Ray was appointed Chief Justice of India, the other three judges. Then started the interference in the judiciary, because the then Law Minister, Mr. Kumaramangalam, said, we want to pack the courts with judges who understand our field. I'm not quoting, but basically this is what he said. Now, then the tussle started. And the emergency was the darkest years for this country. Those of you who have not seen the emergency must read about it. I was a student of law when emergency took place. I've seen some aspect of it. Those of us who have seen the emergency we never want to go back to days like that. Yesterday I was on YouTube listening to an old interview of Ali Nariman, and he talked about the days of the emergency, and he said that there were two stalwarts of the bar, C.K. Daftari, who was the former Attorney General of India, and one Chandu Bane, who was one of the senior-most lawyers. And they both, Desai, one Ashok Desai's father, forgetting the name. So they were both came and sat down in the bar room. Justice Mr. Daftari lit his pipe, and the other man, Mr. Desai, also lit up a cigarette, but they were both quiet. The other gentleman says to Daftari, Chandu, kuch bolo na. He says, tum pehle bolo. Those were the days of the emergency when two close friends would also not talk, not wondering that if I say something wrong, I may be behind bars. And these were the top lawyers of the country. We don't want to go back to this. No doubt, some may argue that the collegium has been brought in by constitutional judgment. It does not find place in the constitution. But you must remember the background in this picture. Judges were being transferred, inconvenient judges were being sent back. And therefore, we had the spate of the three judges case, S.P. Gupta, and the last ending in the reference to the Supreme Court of India. During the emergency, we had another famous or infamous habeas corpus. V.N. Shukla was State of Madhya Pradesh. 9 high courts. You know, people say the emergency, the judiciary is the darkest time for the judiciary. In a part, I agree with the part. The Supreme Court reached its nadir, the lowest point during the emergency. But people forget the role of the high courts. 9 high courts in this country, 9 different high courts in this country had held that even during the emergency, whether external or internal, you cannot take away the fundamental rights of the people. It was the Supreme Court with a majority of 4-1 in this case who said otherwise. So it's not the entire judiciary. And again, going back to Mr. Fali Nariman, he has a very interesting theory. He says in 1975, the Supreme Court was a small child, only 25 years old, they had no history. Whereas the high courts like Bombay, Calcutta, all had an existence of 100 years. So they were established courts and they knew how to handle the executive and the legislature, whereas the Supreme Court was unable to handle the responsibility which fell. Another argument in the collegium system is that in no other country to judges appointed. The idea given is as if in India judges appointed. It's not correct. When the High Court Collegium, 3 judges of the High Court recommend a name, it goes to the state government. The state government looks at the name and sometimes does not agree with the High Court Collegium at all. Then the names go to the Supreme Court Collegium as well as the Law Ministry. It is not as if they don't go to the Ministry of Law. An IB investigation, an investigation conducted by the Intelligence Bureau on the integrity of the person concerned. And those inputs are then given by the government to the Supreme Court Collegium. And I can tell you a very interesting IB report. Do we have time? Yes, we'll be running also. So, IB reports can't also be very, I know of instances where we've been totally wrong. But it is not that the government doesn't have a say. And many times the collegium accepts what is said by the government. The difficulty only arises when there is disagreement. And that disagreement doesn't happen very often. It happens sometimes. Recently, there have been 2 cases of disagreement which have come out, which the collegium has now put out in the public domain. One is of Mr. Saurabh Kripal, who is openly homosexual, who has never hidden this fact. His name was recommended more than 5 years ago. Nobody denies his competence. Nobody denies his intelligence. Nobody denies his integrity. But his sexual orientation was reached. Second was that his partner is a Swiss citizen. There are many people holding high posts whose spouses are not Indian. To name one is a person I respect a lot, and I think he's one of the finest ministers today, Mr. S. Jaishankar, India's Minister of External Affairs. His wife is of Myanmar. I think if I'm not wrong, Japanese. So that cannot be a ground. But worse than that, even worse than Saurabh Kripal, is the case of the gentleman from Madras, whose name was recommended for the Madras. Chennai is where Dr. Ambedkar belongs. Now, his name was rejected on what ground? That he had shared in the social media an article which was critical of the Prime Minister of the country. We are talking of a democracy where dissent is an inherent part of a democracy. Anybody has a right to criticize the policies of the Prime Minister. And he has not done what? He has shared the article. He is not even the author. In my view, even if he was the author of the article, that could not have been held against him to hold that he is unfit to hold that post. What does it show? What does this show? This shows that they want to pack the court with men and women who will toe their line, who will not be critical of them. And if they will not be critical of them, they will uphold every action which they will take. Now, is this a judicial duty? Therefore, young ladies and young gentlemen who are going to enter the legal profession in a year or within this year or 2, I mean, a fervent plea to you, do not let this vision of Dr. BR Ambedkar and the founding fathers of this country be besmirched. It is you have to fight for your own rights. But you not only have to fight for your own rights, but you have to fight for the rights of your brother and sister citizens who may be marginalized or underprivileged and may not have the means to stand up for themselves. It is my request and plea to you, don't let the heart and soul of the Constitution of India die. Keep it eternally alive. do not anybody tamper with the basic structure. No doubt, no system is perfect. There can be no doubt. There is no perfect system. You, the young students, are the leaders of tomorrow. India will be in your hands. If you remain vigilant and protect your rights and work with the view to protect the Constitution, nothing can go wrong in this. I end my address with a quotation again of Dr. BR Ambedkar. This is his last lines when he was addressing the Constituent Assembly on 26th November 1949. I quote, I feel, however good a constitution may be, it is sure to turn out bad because those who are called to work it happen to be a bad. However bad a constitution may be, it may turn out to be good if those who are called to work it happen to be a good. The working of a constitution does not depend only upon the nature of the constitution. The constitution can only provide the organs of the state, such as the legislature, the executive, and the judiciary. The factors on which the working of those organs of the state depend are the people and the political parties, and they will set up as their instruments to carry out their wishes and their politics. Thank you very much.